Fresh trial of former Governor Orji and others over 7.1 billion euro fraud stored as anti-graft agency Efcc raises concerns. Welcome to the news and thank you for tuning in to listen. Please subscribe to our channel. Sahara reporters report that Justice Idris had convicted the Abia State Governor, his company, Slok Nigeria Limited and Udi Jones Udogu for money laundering in charge number Efcc ABG CR 56/2007 between the Federal Republic of Nigeria versus Orji on 2 ORS on December 5th, 2020. The appeal against the Federal High Court judgment that prohibited the retrial of a Senate Chief Whip of a Senate Chief Orji Slok Nigeria Limited, his company, and others over 7.1 billion euro fraud by Economic and Financial Crimes Commission (EFCC) has been stalled since November 2022. Sahara reporters report that Justice Idris had convicted the Abia State former governor, his company, Slok Nigeria Limited, and Udi Jones Udogu for money laundering in charge number FHC ABJ CR 56/2007 between Federal Republic of Nigeria versus Orji and 2 ORS on December 5, 2020. However, following the defendant's appeal against the judgment in which they argued that since the trial judge, Justice Idris, was already elevated to the Court of Appeal, he could not be granted a fiat to conclude the case, and it was done in the Stan's case. The Supreme Court nullified their conviction. In nullifying the trial and conviction, the Supreme Court held that Justice Idris no longer had jurisdiction to try the case after being elevated to the Court of Appeal. Consequently, the court ordered that the case be reassigned to another judge for trial, the Neville. The defendant, Kala, and his company filed application before the Federal High Court, Lagos, relying on the judgment of the Supreme Court for them to be released from a sentence from the conviction since the Supreme Court had held that the trial was a nullity. The application was granted and Kala released from the correctional center. In line with the judgment, the case was later reassigned to Justice R.E. Eko J. of the Federal High Court, Abuja, but the case was reassigned to be tried in Abuja despite the Court of Appeal earlier judgment that held that Lagos and not Abuja has jurisdiction to hear the case. However, at the retrial, Orji, who is the first respondent in suit number FHC ABG CS 73/2021, Federal Republic of Nigeria versus Orji and 2 others filed an application before Justice R.A. Eko J. of the Abuja Federal High Court, in which he sought, among others, a note of court prohibiting the Federal Republic of Nigeria through the Economic and Financial Crimes Commission from prosecuting him again on the allegations in charge number FHC ABG CR 56/2007 between the Federal Republic of Nigeria versus Orji and 2 others on the ground that he had earlier been tried, convicted, and sentenced on the charge. The Economic and Financial Crimes Commission (EFCC) also filed a counter affidavit and written addressing opposition to the application, but ruling on the suit, the court held that the applicant EFCC cannot retry the correspondent. The court held the plea of Otrofeus Acqui and Otrofeus Convey and the principle of double jeopardy availed the first respondent Orji and the retrial of the first respondent would amount to the violation of the provisions of Section 36, 9, and 10 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, and Section 238 of the Administration of Criminal Justice Act, 2015. Meanwhile, one of the Economic and Financial Crimes Commission counsels in a correspondence obtained by Sahara reporters said that in view of the decision by the trial court prohibiting the Federal Republic of Nigeria through the anti-graft from trying the first respondent, Orji again on the allegations in the filed notice of appeal against the decision, transmitted record of appeal, and filed the appellant's brief of argument. The first respondent also filed his brief of argument together with a notice of preliminary objection. We have filed our reply brief wherein we incorporated our response to the preliminary objection. The appeal first came up on the 7th of June 2022 and was adjourned for hearing of the appeal to the 29th November 2022, but the court did not sit on that date. We have made frantic efforts to get a date for hearing and have applied for hearing. He, however, disclosed that when the seat was reassigned to I.A. Eko J. of the Federal High Court, Abuja, they wrote letters to the Honorable Chief Judge on the Federal High Court requesting him to return the case file to the Lagos Division of the Court, adding that they informed him that the case was tried and concluded in Lagos, and that the Court of Appeal had held that Lagos and not Abuja has jurisdiction over the case. However, before the Chief Judge will respond to our letter, the former Abia State Governor had filed the application in suit number FHC ABJ CS 73-2021, saying that he will not be tried again. The Chief Judge then responded to our letter in his lordship later dated 21st of January 2021, though received much later, indicating that we should await the decision in suit number FHC ABJ CS 73-2021 for him to determine whether he would need to act on the letter. After IA Echo J granted Orji's prayer in suit number FHC ABJ CS 73-2021 and Slok Nigeria Limited prayer in suit number FHC ABJ CS 475-2021, the two of them filed an application for their names to be removed with charge number FHC ABJ CR 56-2007 between Federal Republic of Nigeria vs. Orji and two others, since the court had held that they should not be tried again. We filed counter affidavit to the said applications and filed at the Court of Appeal applications for stay of execution of the decisions in suit number FHC ABJ CS 73-2021 and suit number FHC ABJ CS 475-2021. We also filed an application before IA Echo J for him to transfer charge number FHC ABJ ICR 56-2007 between Federal Republic of Nigeria vs. Orji and two others back to Lagos Division of the Federal High Court. On the 22nd of July 2022, ruling was delivered wherein his lordship ruled that the applicant's application to transfer the case back to the Lagos Division of the Federal High Court was an abuse of cause process, and the applicant's prosecution's counsel was ordered to show cause why he should not be disqualified from prosecuting the charge. This decision of the trial court was reached notwithstanding the fact that the charge was initially tried and determined at the Lagos Division of the Federal High Court in accordance with the decision of the Court of Appeal in Appeal number CA A870 2017, which is still subsisting. Motion number CAABJ PRE ROA CR 1125MV 2022 was subsequently filed at the Court of Appeal seeking an extension of time to apply for leave to appeal against the said ruling of the Federal High Court, Abuja. Quorum IE Echo J delivered on the 22nd July 2022 in charge number FHC ABG CR 56-2007 between Federal Republic of Nigeria vs. Orji and two others. He noted that application had not been opposed by any of the respondents as it is subsisting. Wow, this one long ago. So they're trying to reopen Orji case. Let's see how this one goes, Sha. Let's see how this one goes. Alright, and this was we've come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy the rest